Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning, Waukesha. Good morning, Wisconsin. Good morning, America. I am delighted to be with you again this morning. This is our third show in the month of June. Jim Santel, Morning Cannolis with Jim Santel. We're once again here in the studios of WAUK in downtown Waukesha. Beautiful downtown Waukesha today, and delighted that you have decided to spend some time with me and also with Connor here in our production studio talking about the significant issues of the day. This is a weekend review of the important stories in law and government and the aspiration for justice in America. Once again, I'm so pleased that you're spending some time with us in discussion of some very significant issues coming up and some things that have happened in the recent past. We've got a very aggressive agenda, and hoping that you will also spend some time calling in today at 844-967-2789. Pleased to be with my friend and colleague just a few moments ago, Don Paul Brown, in his program this morning, talking about all good things happening in Waukesha. We're going to be chatting again about things happening in America, in our state of Wisconsin, and beyond. And so let me talk first about the syllabus for this morning, what our plan is for this hour and then the second hour as well. This morning we're going to follow up on our first conversations in our first two shows talking about, the United States Supreme Court. You may recall well that in our first couple of shows, we chatted about guns, this case called Bruin coming out of New York. And we chatted also about the upcoming decision to be rendered by the United States Supreme Court in a case that likewise is going to change America, we suspect, and that case is Dobbs. We're going to be spending some time talking about the environment, chat about religion, and also talk about immigration in the second portion of our first hour this morning to fill you in on some additional cases likely to be decided as soon as perhaps this coming week, maybe in the weeks just ahead. And then the second hour, we're going to turn to the January 6th Commission. The committee is looking right now at what happened at, around, before, and after January 6th. Do some big takeaways on those, and once again inviting your calls not only on the Supreme Court case issues, but also on the importance of those hearings. What's ahead, what is behind as we look forward and backward here in the United States of America and right here in the state of Wisconsin. Every morning I've been beginning our program by talking a little bit about history, things that have happened on the day that we're getting together to chat, to have these conversations. And today is no different, although today, rather than talking about a number of different things that happened, for example, on this day in history, on June 18th in the past, I'm going to talk about just one because it also is a good tease, if you will. It's a good invitation to our second hour as we're going to be chatting about the behavior, the conduct of a former administration, a former president in our nation's history. But I'm going to go back 50 years ago yesterday, and yes, indeed, today. 50 years ago today, we were waking up. We were waking up to some news about a curious event that happened in Washington, D.C. Let me set this up for you and talk about what happened on June 17th and in particular June 18th as we began to discover as a nation a significant event that changed forever the course of American history. It was 50 years ago yesterday and 50 years ago today that a 24-year-old security guard, his name was Frank Wills, again changed the arc of American history. About an hour earlier, about 2 a.m. or so on Saturday, June 17th of 1972, Frank Wills, who was a security guard at a particularly significant building in Washington, D.C., noticed and dutifully removed a small piece of duct tape that had been placed over the lock of a door that he was required to check on during the course of his reviews and his walking through this building. That was a part of his morning routine. He didn't make too much of it then. He thought maybe that duct tape was there because it was some vestige, the leftover of an effort to accomplish with speed and with ease some routine package delivery that early morning or maybe earlier in the evening. He reacted differently, very differently. When about 45 minutes later, he returned to that same spot, the same spot that he had been earlier, and discovered that someone had put more tape on that very lock that he had previously been visiting, looking at, and removed the tape from. Supposedly, according to his story and certainly the story of the police that morning, Wills appropriately, urgently called the police. He said something is wrong here. Something is very amiss. He had his security telephone at the main lobby of this building. Summoned the police from the nearby 2nd Precinct. He perhaps knew them well because of his work as a security guard in this particular building. And upon their arrival, those law enforcement folks came upon Mr. Wills, talked with him about what he had found, and immediately began to shut down the power to the elevators in that building, locked all the doors to it to keep any early morning intruders from accomplishing an escape. While the police were there, while Wills was also with them, responding to this curious thing with the tape on the door locks. And so throughout the entire time of Wills' tenure as a law enforcement person responsible for the safety of this building, there had been only one other instance that Wills could catalog, was an attempted burglary. Any other significant event probably he didn't recall well, and his assignment was otherwise pretty sleepy, fairly routine. But this particular discovery, that particular morning on June 17th and into June 18th, changed his life, changed our lives. And Wills, along with these police officers, were accompanying each other as they went door to door, room to room throughout this building, and tried to figure out who was in the building, who was improperly there. While some of the aspects of the police report differ somewhat from place to place and reporter to report, the reality is that Wills had come across something very significant. He said this later on: when we turned the lights on to a particular room that they finally came upon in this building, one person, then 2 persons, then 3 persons came out and down the line. That was Frank Wills, early morning Saturday, June 17th, and then also into the 18th of the following day. To that stirring account of his attentive work that night with the other police officers, we add, and we know now, the names of the people who came out in this attempted burglary on that very early morning. And we know their names. We know they're a part of history now, not a good part of American history. Their names were Bernard Barker, Virgilio Gonzalez, Eugenio Martinez, James McCord, and Frank Sturgis. And you're probably getting a sense of what this is all about just by virtue of their names. Wills and the other law enforcement officers who were responding to all of them did a couple of things. They were taken into custody, that is, the folks coming out of this particular room that they were in, and they confiscated from them a great deal of materials, some products, some things that they were using, and that include a bugging device, some camera equipment, some film, lock picks, a series of numerically sequenced $100 bills, and all of that would become very significant in terms of what was about to happen. Wills quite literally changed the course of American history. We'll get back to exactly what he did in just a moment, but there's a story behind Wills as well. Wills, as a result of what happened that early morning, the day that followed 50 years ago, right now, Wills had asked his supervisors, he had been a good employee, and after his long-standing history, he sought a raise. He wanted a raise from his basic rate of $80 a week. Today it would be about $500 or so, and that was regrettably denied. And so Wills left that security position and spent many years following in an unsuccessful pursuit of stable employment, quite frankly. And Wills confirmed that later on in his life. He spent some time in our nation's capital. He had a security job at Georgetown University. He went to some other southern cities and eventually the Bahama Islands as well. And ultimately, he relocated in North Augusta, South Carolina, where his mother was, his family was. He very lovingly, according to his own reports and those of his family members, lovingly cared for his mother following her suffering a disabling stroke. And through his early middle age, Wills planted and nurtured a very expansive home garden with his mother. He went to the local library to pursue his academic interests and sort of reveled in the quiet company of his cats. In 2000, right before that, he was diagnosed with a brain tumor, and Frank Wills died on September 27th of 2000 at the Medical College of Georgia in Augusta at the age of 52, much too young. But he did change. He did indeed change American history. on the occasion, the 20th anniversary of, yes, you know what I'm talking about, the 20th anniversary, 50 years ago today, but on the occasion of the 20th anniversary of the abortive break-in, and yes, that's right, at the Watergate complex on the shores of the Potomac River in Washington, D.C., Frank Wills said this. He said he would do it all over again. And when he was asked about his motivation, why he was doing what he was doing on that early morning and into the day of the 17th and 18th of June, he said, you know, that's like asking me if I'd rather be a white man or a black man. It was just a part of who I am, he said, just a part of destiny. Everybody tells me I'm some kind of hero, but I certainly don't have any hard evidence of that. I did what I was hired to do, but still feel a lot of folks don't give me the credit for what happened that night and didn't give me the chance to move forward. That was Frank Wills on the 20th anniversary of the Watergate break-in. And then we finish up this reference to history and our own American history again that changed a presidency, changed the course of our own national livelihood. New York Times offered perhaps the most eloquent description of Wills' role in American history in saying that a eulogy was delivered by United States Representative James Mann. He was from the 4th Congressional District of South Carolina. Upon his vote as a member of the House Judiciary Committee to remove a sitting president, yes, we know that's Richard Nixon, a vote to remove him from office to return articles of impeachment for what turned out to be the Watergate scandal in 1972, 1973, and years that followed. And James Mann, in giving this most eloquent description of Will's role in American history, said this: if there was no accountability, Mann said, another president will be free to do as he chooses. Another president will be free to do as he chooses. But the next time, Mann said, there may be no watchman in the night. History making event 50 years ago, these days, right now. And so we hearken back to that time in our nation's history 50 years ago, the Watergate scandal and the things that happened. We're going to talk more about that in the second portion of our time together this morning. Right after the break, we're going to get back to the United States Supreme Court, talk about their activities coming up. We're taking your calls also at 844-967. This is WAUK in Waukesha, the Shah, 540 AM, 101 FM. This is Morning Cannolis with Jim Santel. And we're back. This is Morning Cannolis with Jim Santel. It is Saturday, June 18th. Thank you so much for joining me for our program this morning. I'm here in the studios of WAUK Waukesha, WAUK Radio, right downtown Waukesha along beautiful Wisconsin Avenue this morning. I'm here with Connor, who's my producer. We're taking your calls as well during the course of this first hour and then also the second hour. Our syllabus today, as I indicated, is discussion more of the United States Supreme Court today. Additional cases they're going to be rendering probably this week and next week. And then our second hour chatting about January 6th. Good bookend, if you will, to our introduction this morning about what happened 50 years ago this weekend. This week, these days, the beginning of the Watergate scandal and the Watergate matter that toppled the president and changed our history. We'll talk about the extent to which those present events related to the January 6th insurrection and the riot at our Capitol will also change American history. It already plainly has. We're taking your phone calls at 844-967-2789. So let's jump right back into our focus of the past several shows. Again this morning on Supreme Court cases. The United States Supreme Court continues to meet. This is its 2021-2022 term. Its next term is going to be beginning in October. We're going to chat more about that at the end of this half hour or so. We have have talked before in our first two shows of this month of June about two major cases that the Supreme Court is likely going to issue. Could be as soon as this coming week, certainly in the following weeks, probably sometime in July. Additional cases coming out from our high court. And you may recall well, those of you who tuned in, that in our first show way back in early June, on June 4th, we talked about this case called Bruin coming out of New York and the possibility that the Supreme Court wrestling with Second Amendment issues, determining whether or not there is a constitutional right and a right under the Constitution of the United States of America to carry, perhaps concealed, perhaps open, on the streets of America, the sidewalks of America, a firearm, extending a case called Heller, decided 14 years ago, that established a constitutional right for every American to own and use a weapon in the privacy of her or his own home, for the traditional use of self-defense. So that was Heller 14 years ago. The question we're waiting to hear from the Supreme Court on is whether that gets extended beyond the home into the streets and sidewalks, other public places of America. Likely the Supreme Court is going to expand that right, that vision, that view of the Second Amendment, but also indicate that there will be some appropriate limitations on place. Secure places, places where we cannot have guns, places where people convene, schools, hospitals, other places of a common congregation, theaters, sporting venues, all sorts of places where it will be appropriately to impose regulations and conditions on the presence, certainly the use of firearms. Well, we're anticipating that Bruin case coming out soon. The second one we talked about in our second show was the one that perhaps the United States generally is focusing a huge amount of time on these days, and that is Dobbs, this case coming out of Mississippi, determining whether or not there is a continuing right under the Supreme Court past rulings in Roe versus Wade, a privacy right for women, and I would offer also men, to make decisions about reproductive rights. Is there a privacy right to an abortion in America? We recall well Roe versus Wade way back in 1973, a decision rendered by Harry Blackmun and majority of the Supreme Court at that time, finding that yes, indeed, privacy rights do give women the right to make that choice. And the question in Dobbs is whether or not the legislature in Mississippi that passed this 15-week prohibition on abortion access, if that is consistent with Roe versus Wade. I think most people say it is not. And if it's not, is the Supreme Court about to overrule Roe versus Wade and establish some new principles under privacy doctrines, other ways of thinking about abortion as those issues play out? So we're anticipating both of those cases, and we've spent a lot of time chatting about those, and I appreciate your calls, your thoughts, even off air about those. This morning, in our remaining time in our first hour, we're going to chat about three other cases, three other things on the docket, the syllabus, if you will, also much before the Supreme Court these days, also coming out very, very soon. Let's chat about the first one of those. I'll give you a little sense of what's coming down the road. We're going to talk this morning about immigration and religion and the environment. So no small topics here this morning on Morning Cannolis. Let's talk first about this big environmental case. The name of the case, we're anticipating a decision from the Supreme Court. Write this down. Talk to your friends, your family members about it. It's called West Virginia versus EPA, the Environmental Protection Agency. A major case pending before the justices. It could, in fact, redefine the federal government's power to regulate a main contributor to climate change. At issue fundamentally in this particular case is a dispute over the authority of the EPA, the Environmental Protection Agency, to address air pollutants from power plants. All right, the central question in West Virginia versus EPA is whether that agency's reach beyond the confines of plant sites to encompass broader aspects of U.S. energy policy, whether that's appropriate. What is the extent of the agency's capacity, the executive branch's ability to issue rules under its established practices, especially when it comes to the area of greenhouse gases. And many of you may remember that President Obama issued something called the Clean Power Plan during the course of his tenure as our president, and it did in fact set goals for states to reduce greenhouse gas emissions from those power plants. There were a number of state challenges. You may also recall this much in the news a number of years ago, and ultimately the United States Supreme Court did temporarily, for a time, block the rule of the EPA that establishes these limitations and these goals for greenhouse gas emissions. President Trump, when he became the president, repealed that plan, and his position of his administration was that it exceeded the authority of the agency, this rulemaking authority, this administrative authority to act in this area of environmental action and behavior and conduct. And so the President Trump and his administration supported and advanced a more lenient rule, kind of relaxing the things that President Obama had put in place. That executive decision was also challenged, and on the other side of the break, I'm going to talk with you about where that case stands right now and exactly what the Supreme Court's going to be telling us in the area of environment very, very soon. Come back, talk with us more about an environmental case, West Virginia versus an EPA, right here this morning on Morning Cannolis with Jim Santel. And we're back. This is Jim Santel with you this morning. Thanks so much for joining me here on the air, WAUK radio. It's 540 AM, 101 FM. We'll be taking your calls as well throughout the program this morning at 844-967-2789. In our first hour this morning, we're revisiting the work of the United States Supreme Court, anticipating major decisions coming out perhaps as soon as the days just ahead, the coming business week, certainly the later weeks and days here in June, and probably also into July. We'll talk more about the schedule of the United States Supreme Court at the end of this particular hour. Right before the break, we're chatting about an additional case beyond the guns case, beyond the abortion case, which we have discussed previously. The case we're chatting about before the break was West Virginia versus Environmental Protection Agency. This determination about whether or not the original Obama Clean Power Plan that affected greenhouse gas emissions, whether that's legitimate, who's got the authority to impose rules through the EPA on these kinds of things. Lots of challenges going on there. And the questions before the United States Supreme Court are just those. Who can make these decisions? Should, in fact, the legislature, the United States Congress, principally be responsible for issuing and passing legislation that impacts greenhouse gases in the environment in particular? And in particular, does this rule, the Clean Power Plan rule by the EPA, does that pass muster? Is it legitimate? A challenge to that? As I said right before the break, the executive decision by President Trump to basically rescind the plan and impose his own lenient rule, that was challenged. And on President Trump's final day in office, a federal appeals court vacated that reversal, if you will. So lots of lawyer procedure going on in the case. But the Supreme Court, again, going to issue fairly soon a major case in the environmental area, West Virginia versus an EPA, plainly having to do with climate change. Watch that one as well in the area of environment. Let's move on to yet another matter in the area of immigration. The justices are soon going to be issuing a decision over the Biden administration's break with, again, the Trump-era decision about immigration policy. How does this case come about? The case itself is called Biden versus Texas. And the history on this case is that President Trump instituted something called the Migrant Protection Protocols. You may recall this as the Remain in Mexico policy. The traditional practice, although with a whole lot of exceptions and some particularities that we won't get into this morning, was and still is that if you apply for asylum, you're seeking asylum in our nation, escape from your own nation of origin because of a threat to you, your family, all sorts of categories. When you apply for asylum, one of the provisions is that you can, in fact, be here in the United States of America while the government authorities are passing on, reviewing your asylum application. And so that was the policy, the rule for many, many years. During the Trump administration, the executive branch, the administration, implemented this migrant protection plan, sometimes called the Remain in Mexico policy. And you may remember this very well. The rule basically returned about 70,000 asylum-seeking migrants to Mexico while their applications were awaiting decision here in the United States of America. Lots and lots of coverage on this in the media, both national and international. When President Biden became the president, he rescinded that policy. Again, you see a strong pattern here this morning. Different administrations coming in on the environment and immigration, changing rules, changing administrative procedures here. President Biden comes in, rescinds the Remain in Mexico policy, based principally on human rights concerns. That's what he articulated at the time. Certainly things seen in the media as well, suggesting that there are human rights challenges by virtue of the safety and security of the people who are now even on the other side of the border, no longer getting the protection of our nation, even as their applications are pending. And so what happens is the states of Texas and Missouri sue in federal court. All these cases obviously percolating up through the trial courts, the federal appellate courts. They sued to enforce the protocol, which was the Trump administration plan, the Remain in Mexico policy, basically pushing back on the rescission of that policy, the removal of that policy by President Biden. And they maintain that the problem with it is that it failed to follow something called the Administrative Procedures Act. The APA is common within all these areas. Anytime there's rulemaking going on, including the environment, including immigration, many, many areas of government practice and engagement, the APA prescribes the mechanisms by which executive branch agencies have got to announce rules, give all of us a chance to be heard on it, issue comments, have hearings on it, and it is often a practice of folks on all sides of the political aisle to attack decisions that they do not necessarily like based upon incomplete processes, inadequate, maybe even just plain wrong processes under the APA. So that's what's going on here in Biden versus Texas. Those who do not like the fact that President Trump rescinded the Remain in Mexico policy are maintaining that he did that without compliance with the APA. And that's what the Supreme Court has in front of it. Yes, this very technical, kind of, again, lawyer-like approach on whether the APA applies. It certainly does. But what the implications of its application are for the particular Remain in Mexico policy, these migrant protection protocols at the focus of this. While that's kind of the narrow issue in front of the court right now, again, the larger issue is important for all of America, all of us. Here in the state of Wisconsin, throughout the Midwest, cities, villages, towns, all of us, I would offer in this area in particular, related to our relationship with nations throughout the planet, right, across the globe, because it is an immigration issue, much like the other issue we discussed in the area of environment, West Virginia versus EPA, also has an impact beyond just the United States of America. Biden versus Texas, the same kind of thing. And so the Supreme Court, yes, is going to issue an opinion in this very important immigration matter as well. Immigration, likewise on its docket, talking with us about the extent to which the Remain in Mexico policy can in fact be rescinded, whether or not it still has vitality to this day, and along the way giving us some fairly good definition about what immigration means in America today. So again, as we take some inventory of what we've talked about, we talked earlier about all these very, very high-ticket, high-visibility items: guns, abortion, environment, and immigration. And now we'll turn to yet a fifth area, and this one is also hot ticket. Reasonable people can and do, in fact, disagree on it, and it has to do with religion. Religion. Under the First Amendment to the United States Constitution, as we all know, as we've talked about before in previous times here on the show, the First Amendment, as you well know, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Other important aspects of that first article, the first part of the Bill of Rights, also having to do with freedom of speech, freedom of press, the right of people to peaceably assemble, to petition government for redress of grievances. But this morning our focus is on those first two aspects, the establishment of religion clause, the prohibiting the free exercise thereof clause. And what does that mean? A huge amount of litigation out there in the past, many cases at the Supreme Court level, at the appellate court level, the trial court level, interpreting that language written by James Madison and people like George Mason a couple of hundred years ago. What does it mean today in America? And so, believe it or not, there are not one but two cases on religion pending right now in this term, the 2021-2022 term of the United States Supreme Court. It's going to define for us as we go forward what religion means in America today. What about establishment of religion? What about the free exercise clause? What do those concepts mean today? Do they conflict? And if so, which one takes precedence? Which one is supreme over the others? Let's talk about those two very important cases that are out there. One of them is called Carson versus Macon. Carson versus Macon is the case. It's one of two religion cases pending before the United States Supreme Court. In Maine, some students are lawfully permitted under state legislation to use state-allocated funds, your tax dollars in Maine, basically, to attend private schools. And why is that? Because in Maine, there are certain places, according to the legislature and the executive branch that's responsible for implementing all of this, there are certain places in Maine where public schools are simply inaccessible. I'm sure that that's the case in many situations around America. And so in Maine, students can use state-allocated funds to attend private schools if there are no public schools in their particular area. Right after this next break, we're going to talk about the implications of that as we go forward and chat more about Carson versus Macon in Maine, religion, and the importance of that issue. Come back, WAUK Radio right here in Waukesha, Wisconsin.
Telling me the things you're gonna do for me. I ain't blind and I don't like what I think I see. Taking it to the street. Taking it to the street. Taking it to the street. No more need for running. To the street. Oh, no. Take this message.
And we're back. This is Jim Santel, Morning Cannolis with Jim Santel. I'm here in the studios of WAUK Radio in beautiful downtown Waukesha, right here along Wisconsin Avenue. And this morning we're chatting about additional cases before the United States Supreme Court. Things, issues, concerns, challenges that are going to implicate many aspects of our lives and our livelihood in the United States of America, not just now, but in the future. Right before the break, we were chatting about this case called Carson versus Macon, coming out of Maine. Maine giving school-age children the right to a free public education. But because many of the rural districts in Maine lack a public high school and other schools, our legislative, basically a workaround was put in place that permitted those students to attend nearby qualifying private schools with public assistance, with public tax dollars. So where does the problem come in? Where does the challenge come in? Well, under Maine law, schools that offer religious instruction are ineligible, and the Maine authorities say the reason for that is that under the First Amendment, they would be establishing religion religion as a government, if in fact they were to use your tax dollars to support religious education in Maine. This exclusion, sometimes called the sectarian exclusion, a policy that makes K through 12 schools with religious instruction ineligible for taxpayer-backed tuition aid. That's the basis for this challenge. The challenge is basically under Carson versus Macon. It was brought by Maine parents who say that barring their family's preferred schools from the tuition aid program based on religion does what? It violates their constitutional religious rights under the First Amendment. And their claim, their position is that under the related clause of the First Amendment, that the Maine authorities are affecting, are dampening, are taking away their free exercise right. And so you've got this challenge between the two phrases, the two clauses of the First Amendment, the Establishment Religion Clause, which the state of Maine is implicating and is bringing forth to justify its exclusion of private religious schools from the possibility of getting funding for school-age children. And you've got the parents who say, gee, if you exclude me from that, you are violating my right to free exercise. And so that's what's before the Supreme Court right now. Which one of those? Can they be reconciled? Which one of those has precedence over the other? And does Maine win? Are they right in establishing or not establishing a religion and going forward and implementing and enforcing its law? Or are the parents right? Are the parents right in advocating for this notion that under their free exercise rights, under the first article of the Bill of Rights, they should have the right to have their students, their children, attend a private school, a religious school, using tax dollars? Not an easy case. We know that in 2020 there was a case called Espinoza versus Montana Department of Revenue, and basically the court at that time found that the state of Montana can't exclude religious schools from participation in a scholarship program. States have to allow religious schools to participate in programs that provide scholarships to students attending private schools. So in that particular case, the Supreme Court sided in favor of the religious interest and found that the government interest in not establishing religion was overcome, if you will, by the free exercise rights of those parents and those students, also raising a concern and a challenge under the First Amendment. So the name of that case, once again, Carson versus Macon. Carson versus Macon. And yet there's another case, a second case in the broad category of religion, and it's also pending for the Supreme Court right now. And this is one that you probably also saw in the news not too long ago. The facts in this case, problematically, are not entirely clear, and the Supreme Court justices at the time of the oral argument were sort of frustrated by this, did not have clarity on this, so it's entirely possible that they may send this back to the lower court for some clarification of exactly what happened and what didn't, or they may choose the facts that they think most compelling and reach a certain result. So what's the case all about? What is it called first? It's called Kennedy versus Bremerton, Bremerton School District. Kennedy versus Bremerton School District. And again, you may have seen a lot of this story on the news because it's one that we see virtually every week. High school sports for years and years. We've got a high school coach. He is in Seattle. And for many years, again, according to one version of the facts, after every single game, he prays. He prays at the 50-yard line of his football field. And, of course, we don't intrude into his individual prayer, but it follows games that his team has been playing in on the field. And everyone knows that the high school coach has been doing this over time. Some of his players have joined him in that. First, a small number, and now, according to one set of the facts, the entire team now prays with him at the 50-yard line. And, of course, the high school coach maintains that his prayer, his decision to kneel down along the 50-yard line for a long period of time, this has been going on historically for many years, that he should have that right to do that because under, again, the first article, the first portion of the Bill of Rights, Article 1, he's got a right to the free exercise of his religion. And again, you should know under past precedent that the Supreme Court has said that indeed there is a right under the First Amendment to the Constitution to exercise your religious faith, your religious views, free exercise of religion by doing what? You can pray in school. You can open up the Quran, the Bible, the Torah, and you can have private prayer if you would like. Obviously, appropriate circumstances, appropriate time and place for the instructions got to go on as well. But school prayer is not forbidden, but it's got to be individual. What I can't do, you can't have a teacher, you can't have the administration compel an entire class, for example, to open up the Bible, open up the Torah, the Quran, other books of spiritual inspiration. I can't have them pray as a group because that's, once again, institutionalizing inside the government, inside the school district, the notion of religion, and that would run afoul of the establishment of religion clause. So we know that you can do it individually. Students can do that, and presumably teachers, and even a school coach can do that. The question is when it becomes broader than that, when it is in fact more of a class, in this particular case kind of a team, how do those weigh out? Okay, so the high school teacher, the coach, he's initially reprimanded. Eventually he is suspended from his Seattle teaching and coaching job there because they maintain that he has now run afoul of the establishment clause, and by having all of his team members on the field for his prayers. Again, we're not quite certain about all the specific facts here, so we'll wait to see the Supreme Court's rendition of those as well. But under that particular set of facts, as I've described them, the question is whether or not the decision by the school district to suspend, to discipline him is proper, whether it's a proper exercise of their obligations, if you will, under the first article, the First Amendment, establishing that there should be no establishment of religion by an institution like a school district, a school, or in the alternative, should there in fact be a recognition of the coach's position that he's got a right under the First Amendment to exercise his beliefs and pursue his religious beliefs by having prayer. And the mere fact that others join him, members of his team join him on the field, do not undercut, do not compromise in any way his right under the First Amendment to exercise his religious liberties. So again, the case is Kennedy versus Bremerton School District, very significant. What do you think? Call me, 844-967-2789. These are not easy issues. The other ones, obviously, much related to rulemaking, the environmental case, the West Virginia case, lots of rules there, Biden versus Texas under the APA. This one more fundamental to the Constitution. What are those terms, what do those phrases in the Constitution mean? What does establishment of religion mean in this context? Is the school district right, Bremerton School District, in terminating him for engaging in what he maintains is the exercise of his religion under Article 1? And again, we're taking your phone calls on that and any other issues at 844-967-2789. So we've got these three other major cases also being decided by the United States Supreme Court very soon, perhaps as soon as this coming week. Let me talk a little bit about what the Supreme Court has done and how they work and how we can perhaps begin to think about some prediction here. We know that the Supreme Court on a regular basis tells us those times when we do have cases coming up for decision. We knew that there were some decision days just this past week on Monday and again on Wednesday. The Supreme Court issued about 6 different opinions. They dismissed one case, issued some other opinions in a case called Viking River Cruises having to do with contractual waivers. They made some decisions in a case called George versus McDonough, a Veterans Affairs case on benefits, another case on Medicare prescription drugs, reimbursement rates, a couple of other cases as well. Those issued just this past week. And we know that there'll be more cases coming up this coming week as well. Decision days on Tuesday, June 21, and again on Thursday, June 28th. This Tuesday, this Thursday, more cases being decided by the United States Supreme Court. All the 5 we've talked about. Come back after the break. We're going to chat more about that and move on to January 6th. This is WAUK, Morning Cannolis with Jim Santel, taking your calls, 540 AM, 101 FM.
You telling me the things you're gonna do for me. I ain't blind and I don't like what I think I see. Taking it to the
And we're back. This is Morning Cannolis with Jim Santel. I'm in the studios here of WAUK Radio in downtown Waukesha. Beautiful day in downtown Waukesha, coming to you from this wonderful location. I'm here with Connor, who is my producer, and we're also taking your phone calls at 844-967-2789 with our review this morning of some of the major stories of the past week in law, government, and the aspiration for justice in America. In our first hour, we spent a lot of time chatting about a couple more Supreme Court cases, actually 4 in particular, not just a couple, that are going to be decided fairly soon here by the United States Supreme Court. We had chatted in previous weeks about the guns case. We talked about the abortion case. And this morning we also chatted about these other 3-4 cases that the Supreme Court is also going to issue in the area of environment, in the area of immigration and religion. So it's difficult to imagine a heavier docket coming up here. And right before the break in our first hour, I began to tell you a little bit more about the Supreme Court's schedule. They tell you in advance when it is that they're going to be issuing opinions. They don't tell you exactly which cases they're going to be deciding, but we know with a fair amount of certainty when those cases are going to come out. And so the Supreme Court last week indicated that Monday was a decision day and Wednesday was a decision day. And sure enough, they issued a number of different cases, a number of different rulings on those 2 days. The cases we discussed this morning and previously in those 5 different areas were not among those. And so we're getting fairly late in this term in June of 2022. There is a lot of precedent for the United States Supreme Court issuing decisions, including as late as last year, well into July. And there really is no rule that prohibits them from issuing opinions later on in the term. We are still in the 2021-2022 term. This term will not expire until the first Monday in October of this year. It will be called the 2022-2023 term. But more immediately, before that happens, long before the fall, we are going to have a number of weeks, days here when in the headlines on a regular basis, major Supreme Court cases in these 5 various areas. And we know that the Supreme Court has already told us that this coming week and the week after will be decision days among its calendars. On Tuesday, June 21, that's this coming Tuesday, the first day of summer, they're going to be issuing some additional opinions, so take a look at that. Be careful in watching the news there to understand clearly what they're doing and what they're not doing. They may, in fact, issue some opinions in these areas, may wait for some other days. We also know that on Thursday, June 28th, 2 very important things are going to be happening at the Supreme Court. One is they're going to be issuing more decisions on June 28th, so getting fairly late in the month of June, and again, could very easily go into July as well. In addition to the decisions, the rulings that they announce for all of us on that particular day, they're also going to be having a decision conference, a half-day decision conference on June 28th, which suggests again that there will be future decision days, opinion issuance days coming up down the road. So undeniably, we're going to be focusing a lot in America on these high-ticket, these high-visibility issues in the weeks just ahead, including the coming Tuesday. So take a look at your calendars. Note that those are going to be important days in the jurisprudence of our Supreme Court and also the lives and livelihoods of all of us. So from time to time, people ask, well, gee, how does the Supreme Court make decisions in all these areas? Why is it that the legislature is not issuing its own legislative packages on these areas? And frankly, at least 2, if not more, of these cases raise those issues with particularity. And when you think about the immigration issues and the environmental issues, among the others, but certainly those 2, that the United States Constitution almost certainly contemplates that our Congress, our Senate, our House of Representatives would be the basic institution. That branch of government would be the one that establishes policy in these areas. And one of the arguments that's made inside the environmental case, inside the immigration case, is that because the Congress has not acted in years and years and years in a major way in these 2 very important areas, that therefore the executive branch has to do so. And so, again, in our first hour, we talked about President Trump's executive orders and the rescissions of those, the reversals of those by President Biden and President Obama's executive orders in various areas, all attempts by the executive branch to engage and to make rules for America in situations where the Congress itself has not acted. And the Supreme Court undeniably is going to be addressing that kind of issue, telling us whether those actions by our executive branch can go forward and whether these particular actions are legitimate under the Administrative Procedures Act, or whether the Congress under the Constitution is really the only institution that should be deciding these matters as a policy matter, as your elected representatives. Are they the folks, not the courts? Are they the folks who should be deciding all of these cases? So these are big constitutional issues. We have talked before about where this issue comes from, where the notion, the doctrine of judicial review comes from. Goes way back to 1803. Chief Justice John Marshall, again a lion, an icon in our jurisprudence at the Supreme Court level, in a case called Marbury versus Madison, a fight between a couple of our very first chief executives, Jefferson and Adams, about an appointment. And during the course of that opinion, Chief Justice John Marshall said to all of us, words that are still used, invoked by the Supreme Court to this day. The Supreme Court said it is emphatically the province and duty of the judicial department, meaning the courts, to say what the law is. Let me repeat that. It's emphatically the province and the duty of the judicial department to say what the law is. That was a concept that at the time of the passage of the Constitution, even at the time of the writing of the Federalist Papers, wasn't entirely clear. This notion that the courts themselves will decide on the constitutionality and tell us what the law is, not only if the legislature does not act, but also in times when it does act. So we know there are many instances where the United States Supreme Court will take a look at actions by the legislature and determine whether those are constitutional or not. So a lot of big ticket, very heady academic issues going on and being implicated again right now this week in these areas of very, very great importance. We've got guns case coming up. We've got the abortion case coming up, privacy rights along the way, immigration. We've got matter involving religion and, of course, also the environment. All of those big ticket items going to be decided by the Supreme Court, at least in part, in the days just ahead. One decision day coming up Tuesday, June 21, just a few days from now. Another one later in the month, and almost certainly yet another date into the month of July, perhaps right before, right after the 4th of July itself. There's another big event that I've hinted at in the course of our conversation this morning, also coming up in the life and the history of the Supreme Court, and that is its new term. It begins its term every year on the first Monday of October. That will happen again in October of this year, the 2022-2023 term. And why is this particular term significant? We know well that Justice Breyer, Stephen Breyer, who is still making decisions, who is still issuing opinions and concurrences, writing majority opinions, writing minority dissents, he is still on the bench. Even though he has announced his retirement, we know well that he will in fact be retiring after the conclusion of this term. That term will conclude whenever the Supreme Court is done. It's got about 16 more cases altogether to decide. Whenever they've taken care of all their business on their docket, when all that is done, Associate Justice Breyer will formally retire. He will resign from the United States Supreme Court. And who will take his place? We know who that well. That's Associate Justice Ketanji Brown Jackson. Right now, she is a judge in the United States Court of Appeals for the District of Columbia. You recall well that President Biden nominated her in anticipation of Justice Breyer's decision to resign from the Supreme Court. And way back on April 7th of this year, by about a 53-47, Judge Jackson was confirmed to be the next justice of the Supreme Court. She will formally take her oath of office upon Justice Breyer's retirement, his resignation, his final departure from the United States Supreme Court after a long and very distinguished career, and she will become the next member of the Supreme Court, and she will begin to hear cases in October of this year. So that is big history in the life of the United States Supreme Court as we go forward with all of that. We're taking your calls on all those kinds of issues, the important issues before the Supreme Court in the coming days. 844-967-2789. This is WAUK Radio, 540 AM, 101 FM. As we go forward this morning, again, entertaining your calls, your comments about all this, we'd also like to pursue our discussion of what happened this past week and this past weeks at the January 6th committee. Lots of focus in the past several weeks on these public hearings, revealing in many ways the kinds of things that the committee has identified to this point in its month-long inquiry. A lot of that done in camera, outside of the presence of cameras and outside of the public viewing. That has changed, as you well know, in the past couple of weeks. After interviewing about 1,000 witnesses, assembling quite literally a trove of well over 140,000 documents, the House Committee on January 6th, investigating the attack on January 6th of 2021, is finally unveiling some of its findings in public. Promised by Benny Thompson, who is the chair of that bipartisan committee, promised that this will not be all of the information, but indicated that there will be a written report also coming out, presumably in September, presumably before the midterm election, summarizing all that they have found, but revealing now in these public venues, these televised venues, the things that they have found to this time. There have been three highly anticipated and much watched televised hearings, sort of a curated primetime session that began this, describing in general terms the arc of things that the committee is going to be presenting, its overall conclusions about what it has found, and then we've had two sort of sprawling daytime sessions just this past week in which they've been digging more deeply into the findings, the things that they have discovered, and the implications of those for American democracy. And so in the remaining time this morning, moving beyond the Supreme Court cases, not that they're irrelevant at all to the January 6th hearings, we're going to shift our focus to January 6th and talk a little bit more about the things that have happened, especially in the televised hearing of just this past Thursday. Very significant events, circumstances, lots of testimony out there showing videos that, again, are going to implicate not only this report coming up, but also our understanding of what happened on January 6th of 2021. Join us for more of that discussion right after the break. This is WAUK Radio, Waukesha, 540 AM, 101 FM, taking your calls at 844-967-2789.
The time will tell. You telling me the things you're gonna do for me. I ain't blind and I don't like what I think I see. Taking it to the street.
This is Morning Cannolis with Jim Santel. I'm in the studio here of WAUK Radio in downtown Waukesha. My producer, once again, is Connor. We're taking your phone calls at 844-967-2789, inviting comments, questions, observations, and other perspectives on the important issues we're discussing this morning. Spent most of our time up to now talking about Supreme Court cases, anticipating major headlines in the coming days in a number of different areas, including environment and religion, certainly abortion, guns, and immigration. So we'll look forward to seeing those opinions and certainly talking about those in future shows, and that's going to be coming up in the next few weeks or so. Right before the break, we began to have this discussion about some perspectives, some summaries, if you will, some views on what this January 6th committee, led by Benny Thompson, and certainly a bipartisan group of members of Congress, reviewing what happened before, during, and after the insurrection, the riot on the Capitol on January 6th. We know that there have now been 3 public hearings on these matters, on these topics, and they joined a first hearing that happened way back in the fall of last year. Remember the police officers, the Capitol Police, who came forward to set the first stages for the presentations that we're now seeing. Those officers describing the events of those days from their perspective, the physical, the emotional suffering that they endured as they tried to protect the Capitol from the onslaught, the rioters who were coming in. Hugely compelling testimony back then, and I would offer hugely compelling testimony in the bookend that we're now seeing months later after the committee has done further investigation, further pursuit of what happened on January 6th, both before and after that event. And I would offer to you that what we've seen up to this point, especially this past week, especially on Thursday of this past week, committee really putting together a downright remarkable series of events beginning in December of 2020, right after the election. And it was about that time, as the account goes forward and the testimony and the other evidence being presented by this committee shows, it's when the president at that time, President Trump, and his allies, people around him, Rudy Giuliani, a fellow named John Eastman, again, much in the news these days, a private attorney, among other things, John Eastman came up with this memorandum, much now heralded. We've got a copy of it, that outlined a mechanism for restoring, if you will, what he believed, or maybe didn't believe, but nonetheless purported to say was the steal and the way of overcoming that by keeping Donald Trump in office. All of that began to happen in December of 2020 when Donald Trump, our former president, and those allies really had exhausted all of their legal avenues, the things that were available to them. Remember, all of the federal courts had taken a look at this, challenging the results in various states around the country, including right here in Wisconsin. About 60 of those cases, 60 of those judges coming forward and saying, you know what, there's no there. There's nothing here that you can overturn. And it was about that time, according to the committee information and the evidence being presented these days, that the president, the former president, and his allies began to turn to other things, other remedies to keep Mr. Trump in office, principally through the Congress, but through other mechanisms. And what they were doing is they're trying to exploit some of the ambiguities, if you will, as the committee was describing them this past week, in something called the Electoral Count Act, an 1887 law. Yes, it's still effective today. An 1887 law that kind of lays out the processes by which Congress finalizes a presidential election. And they argued in particular this Eastman memorandum and this whole mechanism at the time through Mr. Trump's allies and this sort of behind-the-scenes, now no longer legal process, a behind-the-scenes mechanism, that it was through the vice president, through Mike Pence, who presides over this ceremonial session to count the electoral votes. That was the ultimate avenue through which they would effectively overturn the will of the people, as those electoral votes would indicate, and would quite literally throw the electoral votes out and throw the decision to elect Joseph R. Biden Jr., our president, and if you will, keep Donald Trump in office. And so that was kind of the mechanism that we saw this past week. How do they go about doing that? And again, this morning, in the remaining time that we've had, I'd like to chat and again invite your calls at 844-967-2789 about the two big tranches, the two big movements I see in this area. One, of course, was coming from one of the very compelling testimonial presentations by a fellow named Greg Jacob, who was the principal lawyer for the vice president at the time. Mr. Jacob knew from the very early times that this plan that was being put together, by which basically the vice president would declare that the electoral votes right in front of him were not legitimate. It's obviously had all sorts of predicates even before then. Part of the plan was to have these false electors from a number of different states, including right here in Wisconsin. That was a part of it. An entire mechanism that would lead up to this decision by the vice president to basically throw the election out and throw it back to the states so that there could be further efforts to keep Donald Trump in the presidency. And what did Mark Jacob say about what the vice president knew and what we thought about that time? Compelling stuff. He said basically that he knew that his boss, Jacob's boss, the vice president, he knew that plan was unlawful from the start. Very significant information, again, about what the vice president knew. Mr. Pence's first reaction upon hearing it, according to Mark Jacob, was that there was no way that this was justifiable. And significantly, Mike Pence, again, very much behind the scenes, apparently told his staff that this might be the most important thing that I ever say when he came to describing his own reaction to this proposal by Eastman and by the president to keep him in office. We also had testimony that by January 4th, a couple of days before the insurrection, Mike Pence and Mr. Jacob, his counsel, were quite literally in the Oval Office when Mr. Trump and Mr. Eastman were also there. And according to Mr. Jacob, at that meeting, it was Eastman who admitted in front of the former president that his plan actually violated the Electoral Count Act. And that goes to the prior testimony also of this committee. We had all this testimony early on, the previous hearings and meetings, when you had people telling the president directly, his own Attorney General, Bill Barr, his own daughter saying, Mr. President, there is no there. The election was not stolen. We know that not only from the many, many cases out there, but just no indication of election fraud. This is indeed the big lie, as has come to be called in America. And they're saying that to him on January 4th. Not only the vice president, but others as well. And we're going to talk right after the break about the implications of the Mark Jacob testimony and other things that happened related to Mike Pence on January 6th as those are being revealed by the committee. Come back. Call us at 844-967-2789 as we talk about the January 6th committee, the big takeaways legally and politically and for our government right after the break.
Telling me the things you're gonna do for me. I ain't blind and I don't like what I think I see. Taking it to the street. Taking it to the street. Taking it to the street. No more need for running. To the street. Oh, no. Take this message to my brother. You will find him everywhere, wherever people live together.
And we're back. This is Jim Santel with you this morning, also with Connor here in the studios of WAUK Radio in Waukesha, Wisconsin. Right before the break and during the course of this hour, we're talking about January 6th and the big takeaways from this past week, the committee revelations, principally through some testimony, some video, again, some very compelling information about what was going on behind the scenes right before January 6th, the attack on the riot. And then we can also talk about the day, January 6th itself, that also is incredibly revelatory about what our former president knew and thought about and the role that our former vice president played in pushing back and refusing to go along with this Eastman plan, this proposal to overturn the election and send the decision-making authority back to the states. And right before the break, we were talking about this very, very interesting meeting that's happening on January 4th, a couple of days right before the insurrection itself. Greg Jacob, who is the principal counsel for the vice president in the Oval Office with President Trump and John Eastman, having this conversation about what they're going to be doing. Along the way, according to Greg Jacob, Eastman says, I am here to request that you reject the electors. And again, we know because of what happened next that Eastman knew at the time that kind of request was unconstitutional. There's no basis for it. And indeed, as a part of our focus these days on the Supreme Court, very interesting to note that Mr. Jacob was very certain about having the law on his side, not on the Eastman side. And as they discussed these various legal arguments, all of which were just incredible, not founded, not predicated upon any rational basis, Mr. Eastman, who was the author of this overall design involving electors, involving things going on in the well of the Congress, Eastman himself admitted that his theories would fail 9-0 before the United States Supreme Court if they were ever tested in that particular venue. So we know all of those kinds of things going on. A lot of problems in terms of the internal discussions being had there. And why am I focusing on this? Because it does go to the president's knowledge, right? His intent. A lot of focus these days in the midst of of the revelations by the committee about what the president knew and what he didn't know. We knew last week, we know again this week, that virtually everyone, perhaps including Mr. Eastman himself, the very designer, the author of this mechanism, this unfounded mechanism to overturn the electoral results, all of them knew that what they were doing was not only illegal, contrary to law, but had no viability under any constitutional principle. And that resulted in the president's having to know that his own advocacy publicly at that time and certainly afterwards, indicating that this was in fact a big lie, that indeed the election had been stolen, and that the proposals that he was putting together privately to overtake the election results, the accurate election results, frankly, were inconsistent with what actually happened here. And so along the way during the course of this past week, we also get this very chilling concern about the health and the welfare, the safety, the security of the vice president himself. There's a fellow named Mark Short, who's the chief of staff for the vice president. And a day before the mob violence, after this meeting in the Oval Office, Mr. Short gets very concerned about the president's actions. And he goes to the Secret Service and says that he is concerned about the president publicly turning against the vice president, potentially creating a security risk to Mr. Pence himself. This is his own vice president. And again, underscoring not only the volatility, the horror of what's going on inside our government at the time, right before January 6th, but also perhaps down the road, critically important, the knowledge that our former president had about his conduct. He knew in fact that what he was doing was not only illegal, unconstitutional, but completely contrary to the facts. That may become very, very significant if in fact the U.S. Department of Justice does in fact under Merrick Garland, the Attorney General, decide to pursue a criminal prosecution against any of these players, including arguably the former president of the United States of America. Here's an interesting little insert that goes back to our discussion during the first hour about the role of religion in government and the extent to which the Free Exercise Clause has meaning. Mr. Jacob, who again is the principal attorney for the vice president, says during the course of this horrific event, where we were concerned about his boss's safety and security, pushing back, as is Mike Pence, against the president, these initiatives, these attempts to try to overthrow the results of the Electoral College. Mr. Jacobs says it is faith sustained him throughout the ordeal. And what does he say under oath? He says he pulled out his Bible in the secure location with Mr. Pence and read a passage in which Daniel is thrown into the lion's den after he refuses a king's order, but is protected by God. And I would offer that that's the kind of thing that indeed you can do. That is proper exercise of your religious liberties under the First Amendment, and it's the kind of thing we were chatted about during the course of our first hour. So many of these issues much related. And that one, of course, happening on January 6th, which leads to the other portion of this, which goes to the very events of January 6th, and once again, where Mike Pence was, what he was doing. An incredible, once again, exchange between the president and the vice president. What do we know from the testimony of just this past Thursday? We know that at about 11:20 a.m. on January 6th, the president calls the vice president. The president is at the Oval Office, the White House, calls the vice president, who is at his residence at the Naval Observatory up the street there in Washington, D.C., and the vice president steps away from his own staff that is dealing with things related to January 6th, and they have a conversation, that is the president and the vice president. And the group in the Oval Office could apparently hear this side of the phone call, and during the course of the testimony from witnesses, including Mr. Jacob, during the course of the proceedings this past week, what we know about that is that the folks in the Oval Office hear the word wimp. A fellow named Nick Luna says, and he's an aide to the president, says in a videotape testimony that wimp is the word that I remember. This is the president calling the vice president a wimp, plainly for refusing the vice president refusing to go along with his overall plan to overthrow the election. Mr. Pence, according to all the testimony, including the testimony of his own lawyer, says he is holding firm in his refusal to give in, and this call becomes very, very difficult to ignore, both in the Oval Office and for people with the vice president himself. The chief of staff at that time, the president's chief of staff, Julie Radford, appeared in a videotaped testimony to say that Ms. Trump, this is the vice president's daughter's, Ivanka Trump's chief of staff, not the president's chief of staff, told her shortly after this call that Mr. Trump had this upsetting conversation with Mr. Pence. And the president, Ms. Radford, said, used the P word and said you can either go down in history as a patriot or you can go down in history as something else. This is a very, very not just difficult phone conversation, but truly indicates the complete devolution, the complete breakdown of the relationship between the vice president and the president during that very period of time when all of us were observing things on January 6th. Mr. Pence, the vice president, comes back after this very difficult phone call with the president and tells his staff that he had just had this phone call. According to those folks in the room with the vice president, including Mr. Jacob, the vice president looks steely, nonetheless determined, grim to go ahead and not follow this plan. We know as well that in the hours that followed that phone call, the president goes out onto the ellipse and tells the people publicly who are gathered there, tells the American population, because it was televised, he says, I hope Mike is going to do the right thing. I hope so, because if Mike Pence does the right thing, we win. All of that language, which we remember very clearly from that ellipse event, that happened after this very, very tumultuous conversation between the president and the vice president, plainly the ultimate breakdown in their relationship. And then we know as well, of course, that the vice president is at the Capitol at the time that the insurrection happens. He is beginning to count those electoral votes, and much of that now we've seen in the video as the attack is underway. The other significant thing that focuses on the vice president himself, and again, the extent to which people knew what was going on, and the importance of Mike Pence pushing back against this initiative. We're going to chat about that right after the next break in our final segment, and some final observations about the takeaways from these big events being described by the January 6th committee just this past week. Also taking your phone calls at 844-967-2789. Stay with us for the final segment here. We're talking about January 6th and the big lessons, the big takeaways, information otherwise, from the committee findings.
Take this message to my brother. You will find him everywhere.
And we're back for our final segment this morning on Morning Cannolis with Jim Santel. This is Jim Santel taking your phone calls at 844-967-2789. In these last moments of our time together this morning, talking about January 6th and these incredible events, the relationship between the president and the vice president at that time completely breaking down, this phone call between the two of them in which there's name-calling going on by the former president at the former vice president, the vice president's complete refusal to go along with this proposal put together by John Eastman, others surrounding the president, his decision, his recognition, his advice from his own counsel, his own understanding that what was being proposed here was not legal, not constitutional, and saying, I simply will not do that. And we saw the vice president during the course of the day January 6th, following up on his own commitment, his own understanding, contrary to that of the president himself, that he did in fact need to go forward and do what really is a ministerial act in opening up these electoral votes, announcing them to the Congress. And we know again from the testimony provided by the Vice President's counsel at the time and others during the course of the proceedings of this past week that during the course of Mr. Pence's presence on Capitol Hill, even as he and his wife were arriving there, that this mob was beginning to assemble outside of the Capitol. And that as the joint session began, very significantly, we heard testimony about Mr. Pence's, the circumstances of his releasing this memo to the public, laying out very clearly the Vice President's view that he did not have the power to overturn the certification that Mr. Trump, the President, wanted him to do, and that his lawyer, John Eastman, insisted he do, even though, once again, they all knew that that was illegal. We know about the circumstances there. 2:10 in the afternoon, those proceedings interrupted by loud noises, the mob swarming into the building by 2:24. The Democrats and everyone else are bringing this to at least a suspension at that time. The Vice President has moved off into another area for his security. The President tweets that Mike Pence didn't have the courage to do what was necessary, and by that time the Secret Service had moved Mr. Pence, the Vice President, into the Senate chamber, and from the Senate chamber to his office across the hall. And there again, more conversation. Ultimately, he is led into a additionally secure environment. And we saw those pictures once again of the entourage making its way down a stairway toward some underground loading dock, again at the Capitol. We've seen that a lot, but it was repeated by the investigating committee this past week. And Mr. Jacob, his counsel, testifies this past week to give us some more color behind all of that. He says, "I could hear the din of the rioters in the building. I don't think I was aware that they were as close as that. In fact, they were very close." And as the testimony began to conclude, and as we begin to conclude some of our commentary here, our summaries of some of the most important things from the committee, we have Mr. Jacobs telling us this past week this. He says the Vice President did not want to take any chance that the world would see the Vice President of the United States of America fleeing the United States Capitol. He's talking about the reason why Mike Pence pushed back on any efforts to take him out of the Capitol, to move him to a location beyond where he was going to continue counting votes. Mr. Jacobs said that Mr. Pence did not want to give the rioters the satisfaction of disrupting the proceedings more than they had already done. Here's the quote from Jacob himself. He, meaning the Vice President, was determined that he would complete the work we had set out to do that day. During the course of those meetings that he was having, not one person he ever spoke to was convinced that Mr. Trump's theory was accurate, that it was right. And the Vice President's view, again, was the one that carried the day. Nor, for significant reasons, did Mr. Trump ever check on the Vice President's safety or security in the course of that day. Again, all of that coming out from the Vice President's lawyer himself. The Chief of Staff, likewise Mark Meadows, likewise not checking on the security or safety of the Vice President. In the end, the Vice President does say, today was a dark day in the history of the United States Capitol. He was greeted with applause when he said, "Let's get back to work." Let's get back to work. Back at the White House at the same time, again, according to this account, very reliably, compellingly told by the committee this past week, egged on by some of his advisors. The president told aides that he wanted some folks in the vice president's staff barred from entering the West Wing from then on. And by 3:42 in that morning, it was all over. The new president's victory had been certified, and at that time, at 3:50 in the morning, the president and his chief of staff and others went their separate ways. I have fought the good fight. I have finished the race. I have kept the faith. the vice president's staff member said at the end of that day. And again, what are the big takeaways from just those excerpts from the testimony of this past week? We know now with clarity. That the vice president understood not only his obligation to follow the law, and we know that it stood in complete opposition to what the president himself was in fact doing during the course of the day. And so we understand that all of that, again, a part of the presentation being made by the committee at the time. And as we begin to go into a break, we may have a caller. Is that right? Online. We've got two callers. Let's take those callers in our last few moments here. Let's bring up our first caller who's got some comment and observations to offer to us this morning. We'll take the caller. Let them come on in and have some conversation with them. We'll talk with them right now. And we'll do that as soon as our caller comes up here. Again, we're talking about January 6th and the committee findings of the day. Very interested in having your observations in our last few moments of our time together this morning as we get them up and bring them on to our conversation here this morning. We'll pursue this again next Saturday as well, along with other conversation about the Supreme Court cases, likewise, that we have been talking about. While we're working on getting our callers connected in here, let me, again, to sort of summarize our views and our perspectives of this past week, the very significance in terms of intent and purpose and going ahead as we think about the events of January 6th and the importance of those days. We know that the committee is going to continue to release the results of what it has been doing. We are also very much aware of the fact that the Congress itself does not have the capacity to prosecute anyone, including the people who we've chatted about, engaged in this effort to overturn the election. We understand completely that's only the U.S. Department of Justice. And that's why the other big news that's out there, has been out there for some period of time, is that the United States Department of Justice, under the Attorney General, is plainly looking at these same kinds of issues. We know from at least one person, Peter Navarro, who's been subpoenaed to appear before a grand jury, that investigation is going on. It is plainly parallel to what the House committee is doing, probably looking at the same kinds of witnesses, the same kinds of people who are providing this testimony to the House committee, much of which we've now seen revealed. And we know as well that the Department of Justice is looking at this predicate issue related to the electors. We know that Lisa Monaco, the deputy at Maine Justice, the deputy attorney general, has confirmed for us publicly that the U.S. Department of Justice is looking at the legality and the presence of those electors in state houses around the nation, again, right here in Wisconsin, the presenting of those false electoral documents to the authorities in Washington, D.C., again, as a part of this overall Eastman plan, the president's plan to overturn the election. We know that is also being looked at by the U.S. Department of Justice. Plainly, the Department of Justice does not pursue its investigations in public, and so you're not going to see the grand jury proceedings. Those are necessarily, under Rule 6C, those are necessarily private proceedings. They are not a part of a public presentation. When we will see any of that would be during the course of any presentation of an indictment, an announcement of an indictment by the Attorney General with respect to anybody who might be the focus of this leadership group making decisions. We also may see some connections down the road between that leadership group and those people who have been indicted already, the Proud Boys, the Oath Keepers, the 3%ers, those folks who are actually organizing a lot of the especially volatile things on Capitol Hill. And if in fact those connections are made, whether it's by the House committee or by the Department of Justice, that is additional, plainly very, very damning evidence about the connection between the organizers of this plot, this illegal, unconstitutional plot to overturn the election, and the people who are actually violently doing it, trying to stop and obstruct the course of proceedings on Capitol Hill. There is some promise from Liz Cheney, the vice chair, and from Benny Thompson, the chair, that there will be those connections in the coming days. We know that the committee is going to be meeting again on Tuesday the 21st and Thursday the 23rd. plainly going to have an additional hearing or two beyond that as well to summarize this, probably also in prime time setting. And so we're looking to all of that. We'll take your calls down the road in future sessions here in the morning time, morning cannolis with Jim Santel here at WAUK 540 AM, 101 FM. Join us again next Saturday for more discussion of these and other issues. Thank you so much for joining me this morning, and have a good week. Stay healthy, stay safe, and be well.